Okay, welcome back, ladies and gentlemen. Now is the time to discover different careers in arbitration, from private to public sectors. Our moderator is Mr. Jin Kyu Lee. I'm proud to present him, a former member of Yonsei International Arbitration Association. Everyone, Mr. Lee from Peter and Kim.
All right, thank you. Thank you, Hyewon, for your kind introduction. I remember just a few years back, I was in the audience here at the Yonsei International Arbitration team, and it's an honor to be able to present 3 distinguished panelists in front of you. I remember I used to receive a lot of good advice during these sessions, and I hope this session will be equally, if not more helpful to all the people in the audience today. Now, this session will be special in that we have 3 practitioners and 3 different types of organizations that you can work in for international arbitration. Ms. Myung-Ahn Kim works at a law firm, Ms. Young-Shin works with the Korean government, and Mr. Taehee is with an arbitration institution. So this will be a good opportunity to see perspectives from practitioners in different types of organizations. With that in mind, our first speaker will be Ms. Myung-Ahn Kim. For way of brief introduction, Ms. Myung-Ahn Kim is a partner senior foreign attorney at Yoon&Yang. She currently co-heads the firm's international arbitration and dispute resolution team. And before joining Yoon&Yang, she worked as a foreign attorney at Lee & Co. and of counsel at Holman Fenwick Willen LLP. In addition to her practice, she also worked as an adjunct professor of law at Hankuk University. Now, without further ado, I'll give Ms. Kim the floor. It's all yours, Ms. Kim.
Thank you, Mr. Lee. It's a pleasure to be able to speak or see you all on the same screen, particularly given the fact that we're dealing with very interesting times. We're dealing with COVID-19 and a lot of internal and external developments all around. And it obviously, for that reason, as well as others, it's an interesting time for us to self-reflect and grow together and to, contribute helpful and productive ideas as we proceed with our respective practice. As I understand, the purpose of today's talk or webinar is to share some of our respective experiences and ideas about developing our up and rising members of the international community. Talk about some of the core attributes or areas of strength that we may further develop. And perhaps as your Sundays, who've kind of gone through this area a little bit, earlier, not necessarily better, but a little bit earlier than you in the audience, I do hope that some of the things that I share today will be of use. Now, against that background, what I can share is perhaps some of the personal experiences that I've had in developing my career track in the area of international arbitration, and some of the helpful success stories as well as failure stories, so that you can take out some of the takeaways and reflect and incorporate into your own plans for the future. I personally am a Korean American, and so in comparison to some of you, I may not necessarily fit into the specific mold. I usually joke around with some of my colleagues by saying that I'm more of an alien and hybrid than any type of person or individual that fits into a mold. But that, I think, opens a number of possibilities and applicable situations and areas for you. What I've realized going through my career track is that it's not a specific resume or specific institution or school that will define who you are and what type of lawyer you will become, particularly in the area of international arbitration. But your special and driven, I guess, work and great work and tenacity that will help you define where you stand and how you become a successful practitioner. And I'm also in the process of learning, continuously and developing and refining my skills as well. Coming to more specific areas of specific core skill sets or attributes, as I indicated a little bit or implied a little bit, it's not a special background or specific particular one particular attribute that will become a core factor, but rather a compilation of your experiences and studies that will help you. One attribute that has helped me personally is the ability to communicate not only in terms of oral advocacy, but also in terms of written submissions. As you know, international arbitration is heavily driven in terms of the submissions that are going to be exchanged with the counterparty. And it doesn't, based on my personal experience, it doesn't suffice to just assert your client's own position, but rather see it from a very macro point of view where you can actually tell a story and convince the tribunal your client's side of the story with conviction and obviously merit. But in terms of telling a story, the ability to communicate the narrative on a macro level and sort of explain as to why things are bolded in such a way that your client asserts, that will probably be one of the key factors that will probably not be visible on the actual award, on the surface of the award itself, but perhaps during the decision-making process of the tribunal members as they debate the respective merit of each case from each side and come to a conclusion together. And always remember that the members of your tribunal are human beings too. I emphasize this. Being able to have that EQ as in addition to having a very sufficient grasp of the facts and legal principles. That's basically the fundamentals that you have to master. But on top of that, being able to appreciate the nuances of the emotive issues, as well as the jurisdictional characteristics of the countries where your tribunal members come from, will be that extra factor that will help you convince your tribunal members in the direction that you'd actually see fit under the circumstances. What I usually refrain is talking too much, because I think lawyers like to hear their voices and they talk too much, I think. So I'll just pause here and then see if there are any other comments or observations or questions from the floor. I don't know, Mr. Lee, you're the moderator. I'll defer to you in terms of the stylistic features of the session, but let me pause here and then see if there are other comments that may be added. Thank you.
Sure, thank you very much, Ms. Kim. Then just to facilitate some discussion, since you're working as a practitioner at a law firm, do you think there are some distinguishing traits that a potential practitioner who wants to work at a law firm needs? For example, you mentioned grasp of facts, legal principles. What would you advise some students or prospective lawyers to focus on during their studies or before applying to the law firms?
Let me just mention a couple of things. One is obviously on the macro level, and the other one is on a more specific micro level. On the macro level, once again, being passionate about your case and being able to tell a whole story. Starting from once upon a time, there exists this contract and somebody breached and, the obligations were, not fulfilled, and therefore the remedies that we seek would be X, Y, Z in a convincing manner. Being able to tell that story in a convincing manner takes a lot of great work and the grasp of the facts. It's easier said than done, obviously. We all know this. That takes time, but in order to get to that point, I think on a more micro level, being able to actually tell a story in a succinct and convincing manner takes really good writing skills. And it doesn't really happen overnight. It takes time and efforts. And in terms of the efforts that can be made on a continuous basis, and that applies to me as well, I think it's a skill that can be refined on a rolling basis, on a continuous basis throughout your life. And what I found helpful is basically, defer to the experts. There are so many great oral advocates out there, their submissions, especially in the ISD level, they are actually available to the public. And so being able to understand the facts or the basic background and sort of applying yourself to how they argued their case and how they unfolded their logic in the written submission format would be quite helpful if you are really serious about pursuing this path. And then obviously, you know, media, although there are a lot of media articles, but I wouldn't really refer to every single one of them. But what I found to be quite helpful are editorials from The Economist and the New York Times. They're quite succinct and they actually lay out the fundamentals and know how to apply the fundamental principles to the facts of each case. And it's a really good leeway for you to appreciate some of the policy-driven as well as macro initiatives and ideas that go beyond the realm of your legal practice. And sometimes, you know, as lawyers, we tend to be kind of myopic. So being able to open your eyes to these diverging concerns and questions in the public realm would be quite helpful, because at the end of the day, the members of your tribunal will most likely be lawyers and, you know, former judges and whatnot, but some of them, I tell you, they are technicians and they come from diverse areas outside of the legal practice. And so being able to grasp it and appreciate those nuances in different fields out there in the real world through the window of these media reports and well-written submissions in the legal practice, including the ISD practice, this would be quite helpful. I hope that answered your question, but that's the immediate answer I can give.
Thank you, Ms. Kimala. That was actually very helpful. I could actually agree with all of your suggestions, and especially, I still have about 300 unread emails, I think, from the New York Times newsletters. Maybe I should begin to catch up on those, actually. All right.
Likewise.
I think, yes, that's for everyone, I think. Okay. With that in mind, I think we can now move on to Ms. Yonsei, for way of brief introduction. Ms. Yonsei is a Korean licensed attorney currently working as the Senior Deputy Director at the International Dispute Settlement Division at the Ministry of Justice in the Republic of Korea. Ms. was educated in both civil law and common law traditions, studied first at Seoul National University and then at New York University. Prior to joining the government, she practiced arbitration in major Korean law firms. Now Ms. Yonsei, I'll give you the floor.
Thank you very much, Mr. Lee, for the kind introduction. Yes, my name is Yonsei Arbitration, Senior Deputy Director at the International Dispute Settlement Division, Ministry of Justice of the Republic of Korea. It is my great honor to be invited today, and I send sincere gratitude to the organizing committees and sponsors of this event on behalf of the Korean government. Before I start my presentation or speech, I would like to confirm that this does not represent the official views of the Korean government. So given the strict time limit, I will focus on the following 4 issues. The first would be what we do at the International Dispute Settlement Division. And second, the role of the Government Council, particularly working in the fields of ISDS. Third would be based on the difference between practicing international arbitration in private and public sector based on my personal experience. And finally, I would like to share some useful tips that I personally found as useful in developing my career in this field. So what we do in International Dispute Settlement Division. Our division was established in August 2020, so it's a baby division, but we do a very important part of the work. So our main role within the government is to deal with ISDS case management. ISDS in this context refer to investor state dispute settlement cases, which you may hear quite often recently, and maybe for the next few weeks or for next few months. The government officials working in our division manages ISDS cases filed against the Korean government, working somehow like as an in-house counsel. In addition to the management of the cases, we do several other types of works, for instance, dispute prevention, which includes risk assessment and dispute prevention within the government. And we also provide legal advice to some of the potential disputes, including public international law disputes. We also hold training sessions for officials working in the government or public institutions whose action or inaction may be attributable to the government and may lead to a potential dispute. Our division also participates in ISDS rules reform, which you may not be familiar with, but the UNCITRAL is currently working on an ISDS reform work with its working group 3. And we do participate that working group as the representatives of the Korean government, provide written submissions, and represent the official views of the Korean government during the working sessions held twice every year. You may find the comments of the Republic of Korea on the website of Working Group 3. And we participate on behalf of the Korean government on the exit rules amendment and other reform works. Also, we do participate in investment treaty negotiations, particularly in the parts of the investment chapters. And we also are working on capacity building projects, which I will discuss further later. So as I just spread out, we do conduct various types of works in addition to mere case management. So as working as a government counsel, our role varies on the type of the work that we are in charge of. But the main thing would be the case management, and the first thing that we mainly do is on early stage case analysis, which means preliminary consultation or negotiation when the case is filed, which is generally required under the relevant treaty. These preliminary stage analysis is mainly dealt with by the government officials without the assistance of external counsel. So we conduct communication with the claimant's counsel, and sometimes we provide short submissions by ourselves, such as responses or short comments to the arbitral institutions and so on. And when we really think that the case will proceed into the real dispute, we then select the external counsels to work with us. And after the counsel team has been selected, we conduct a case along with the counsel team, and fact-finding, document collection and review, which is the most critical part for the government's part, as most of the government's documents are privileged and confidential. So unlike other commercial or construction disputes, the government officials provide a very ample role in document collection and review, because some of the documents are even not provided to the counsel team until relevant issues are cleared. And so for some cases, since the establishment of the division, we are providing advocacy by ourselves. This means that the Korean government is trying to deal with some of the ISDS cases without engaging external counsel, and try to do both written and oral advocacy within our division with the attorneys working as the government officials. This is in line with the mainstream of the ISDS practice, because like the US or Canada or Spain, government officials are directly providing advocacy on the disputes filed against our governments. So I hope that this has provided some information and outline of what we do in the Ministry of Justice and working as the government counsel. So as Mr. Lee introduced, I have 6 years of experience of practicing international arbitration in private sector. So if I compare the two, in private, you get to involve into more direct advocacy, as Ms. Kim just mentioned. You do the document review yourself, you do the submission drafting and oral advocacy at the hearing, witness examination, and so on. So it means that you get to learn what the actual advocacy is required, and you do the attorney work in more depth. However, working in the public sector, in cases that you have external counsel, you're more like an in-house counsel. But my experience in the private sector is quite helpful, especially when working with external counsel team, as I know that what work is being done at this particular stage, how the work is being done within the external counsel's team, and what assistance I should provide at the particular stage. So I think that my experience in the private sector is quite helpful while I'm working in the government. In addition to managing the cases, working as a government attorney can have other aspects that you cannot experience when working for the private. For instance, the cases that the government is handling is mostly high profile, which means that the case is quite huge, it is quite complex, and this means that you get to learn various issues throughout the case. You get to meet a lot of experts and world-renowned arbitrators and world-renowned world-class counsel. So this would be a very useful and prominent experience within your career, throughout your career for international arbitration. Also, in addition to case management, when working in the government, you would have to be involved in policy and regulation work, which you cannot experience in the private sector. Also, interstate work provides an ample experience that you cannot experience in the private sector. As I mentioned earlier, the government is providing various opportunities for capacity building. This year, we have sent 2 officials to the Hague Academy, which provides international public law education. So, and we are trying to develop more of that kind of education to provide capacity building opportunities. So finally, some of the career tips that I would like to share. Well, I would like to mention a few, but the first would be the background learning. Although you can start international arbitration whenever you want to, it would be helpful that if you could have some background learning or background, education on, let's say, international law or international commercial arbitration or international investment law if you're interested in ISCS cases. And by learning some of the basics of this legal principles or theories, it will help you to test whether you're actually interested and whether you wish to proceed your career in this field. Second, I would like to suggest that others try to find some opportunities that would help let others identify your interest and passion in international arbitration. Reminding my days at the law school, there are various events and moot courts, right? So you may participate in this moot, FDI moot, which is open to the law school students. Also, I noticed that there are a lot of writing competitions in the field of international arbitration. So participate in one of those events and putting them on your resume would be a useful and insightful tip to identify your interest to others. And one thing that I would like to add after listening to Ms. Kim's comments earlier is that most of the useful tips that Ms. Kim has mentioned as working in actual practice, you could test them and you can have preliminary experience by participating in those moot courts. So I strongly recommend that if you are interested or if you are thinking of pursuing your career in international arbitration, you may consider participating in one of those moot courts during your law school. And networking is quite important in this field. There are a lot of internships, and when you participate in those events, then you may get to know with prominent professionals in this field, and you may reach out to them, get some useful tips in finding jobs or developing your careers. Also, I would like to suggest that you use LinkedIn to figure out what LinkedIn or other websites or internet to figure out what opportunities that you can take. And also, even maybe you can participate in a lot of events and lectures. I noticed that now we are starting to have in-person meetings and lectures starting from this year. So it would be a good timing to start networking with your peers or seniors in this field. For us, the Korean Ministry of Justice, we do hire licensed attorneys as legal officers or deputy directors. However, unfortunately, we do not have regular recruiting as like law firms or other institutions. But whenever we do have a vacancy, we do have a posting on the website of the Korean Ministry of Justice. So if you're interested, I suggest that you regularly check on our website to see whether any vacancy is open. And if you're interested, please do not hesitate to try. Okay, this would conclude my presentation or speech for this afternoon. And I hope this was interesting and helpful or insightful to some young attorneys or young students who wish to pursue their career in international arbitration. And working in the government is quite fun. So I wish that some of you may consider or add working for the government as one of your career options in the future. Thank you very much.
Thank you, Ms. Song. Especially your practical tips and then must have been very helpful for everyone in the audience. And since we have some spare time left, actually, if I may pose a question to you. You mentioned that the Korean government and all governments around the world are trying to do their own advocacy without necessarily retaining an outside counsel. If so, do you see more opportunities for people to join the government, for example, more job career opportunities, etc., with the caveat that you're not expressing on behalf of the government?
Yes, with the caveat that I'm not representing the official views of the Korean government. Well, let me clarify. So I'm not saying that it is the mainstream of the worldwide that they're trying not to retain external counsels. It depends on, I think it depends on the case by case approach. If a case is really huge and really complex and it requires like thousands hours of work, then we would definitely need to retain external counsel with relevant relevant capacity. However, the reason I mentioned the US, Canada, and Spain is that they do their main policy is to conduct respond to any ISDS proceedings by themselves unless specific circumstance exists. So, but I think it's mostly because they do not have any language issue. Is there like English is their mother tongue, right? So what we find a bit difficult within the Korean government is that we do have like English barrier, which is quite huge in delivering advocacy in international disputes. But despite that hurdle, we're trying to build our capacity to deal with the cases as much as we can, so that we could develop our own capacity within the government to conduct some parts of the work that is currently done by the external counsel. So that's our main what would I say mainstream within the government. And I am not in the position to say whether there will be more recruits or more hires in the future, but we are trying very hard to retain more attorneys within the government so that they can work as an attorney specialized in international disputes, including ISDS.
Thank you, Ms. Song. That was very helpful. I'm sure a lot of students are interested in ISDS and government jobs, so I'm sure that would have been very helpful. Now, with that in mind, let me introduce our final distinguished speaker, Mr. Taehee Ahn. By way of brief introduction, Mr. Taehee Ahn is counsel at KCAB International. Before joining KCAB International, he completed his doctorate course in international law, including investor state arbitration. As an attorney licensed in New York, he served as an arbitrator for the VISMU competitions and the FDI moves that we had just mentioned. Now, Mr. Taehee Ahn, let me give you the floor. Thank you.
Thank you very much, Mr. Lee, for your thoughtful introduction. And also, I would like to thank the host committee very much for giving me this opportunity to talk about my career experience as a case manager for international arbitration cases and to share my career advice based on my experience. As was introduced, I work as a counsel at KCAB International. And to briefly introduce KCAB and KCAB International for those who are not familiar with them, the Korean Commercial Arbitration Board, KCAB, is the only arbitral institution in Korea that is statutorily recognized by the Korean Arbitration Act. Since its establishment in 1966, the KCAB has handled over 8,000 arbitration cases, including both domestic and international arbitration cases. And in 2018, the KCAB launched KCAB International as its quasi-independent international division to provide better international arbitration service by accommodating the growing demands of global arbitration users. And before I begin to talk about my topics, I should mention a few notes, like Ms. did. Firstly, there are reportedly more than 260 arbitral institutions around the world, according to the research done by International Council for Commercial Arbitration. Although they may share many similar features in their respective arbitration rules, by benchmarking, especially benchmarking the rules of leading arbitral institutions, the experience as a case manager that I'm going to share will be based on my own experience in administering arbitration cases at KCAB International. Secondly, KCAB has different sets of arbitration rules, including domestic and international arbitration rules. And today's presentation will be based on my experience in managing international arbitration cases. Administered under the international arbitration rules of KCAB. And lastly, my speech will be based on my personal view and experience. So it does not necessarily reflect the official view of KCAB or KCAB International. Now I will begin to speak about the role of a case manager in administering arbitration proceedings. To begin with, I will give you a brief overview of the arbitral process, the process of the arbitral proceedings to help you better understand the role of the case manager. The arbitral proceedings can generally be thought to be divided into two phases, which are before and after the constitution of the arbitral tribunal. Until the constitution of the tribunal, it is the case manager who leads the arbitral proceedings by giving directions to the parties pursuant to the arbitration rules. Under the direction and on behalf of the Secretariat, which consists of all the case managers and director of international arbitration team and the Secretary General of the KCAB International. And once the tribunal is constituted, the tribunal fixes a procedure timetable and issues procedure orders, setting specific instructions for the conduct of the ensuing proceedings after consulting with the parties. And then the tribunal proceeds with the proceedings accordingly. However, even after the constitution of the tribunal, the case manager still monitors each process to ensure fair, effective, and efficient arbitral proceedings. That was a brief overview of the arbitral proceedings. And now I will explain more details about the case manager's tasks. Due to the time constraints, I'm not going to delve into every detail, but rather we'll focus on more salient features of the case manager's tasks. Once the request for arbitration is filed by the claimant with the KCAB, a case manager of KCAB International will be assigned to administer the case. And the first task of the case manager is to check if the request for arbitration contains relevant information or statements required by the rules. and to review the information of the parties, nature and circumstances of the dispute, relief being sought, as well as a relevant contract containing an arbitration agreement. And this is to verify if the arbitration agreement is relevant to the dispute, and the dispute can be administered under the international arbitration rules of the KCAB. Also, this is to find out what kinds of specific procedures will be applied, especially, for example, whether the expedited procedure applies, or if the claims arise from multiple contracts, can they be filed within a single request for arbitration, and the like. And if it is good to proceed with the request for arbitration, then the case manager notifies the parties of commencement of arbitration and sends the request to the respondent. And the next important order of business is to appoint arbitrators. Unless there is other agreement or the expedited procedure applies, in principle, it is the parties who are supposed to nominate an arbitrator, either jointly or one arbitrator by each party in case of a three-member tribunal. However, if a party fails to nominate an arbitrator or co-arbitrators fail to nominate a presiding arbitrator, then the Secretariat gets to appoint such arbitrator. The arbitrator appointment is one of the most important procedures that the case manager plays a part in, because at the end of the day, it is the tribunal who will decide the case. And given the importance of the selection of the arbitrator, the Secretariat endeavors to consider every relevant aspect of the dispute and the prospective arbitrator's expertise and experience in the relevant field of the industry, and the arbitrator's availability, conflict of interest, nationality, and residence. The case manager is responsible for listing up the most suitable candidates for the case for determination by the Secretariat. After the tribunal is constituted, as I mentioned before, the tribunal conducts the proceedings according to the timetable and procedure orders the tribunal issues in consultation with the parties. And when the tribunal is satisfied that the parties had enough opportunity to present their cases, then the tribunal will prepare an arbitral award. And once a draft arbitral award is ready, the tribunal sends it to the case manager for review. And this is another important role of the case manager, to review a draft award, as the award is the final product of the arbitration case under the KCAB's rules. And even if there is no official process of award scrutiny in its rules, in practice, KCAB International's case managers put their best efforts to support the tribunal by checking if the draft is missing any relevant information, important procedural history, or omits to deal with claims presented in the proceedings, besides proofreading and checking the format of the award. So I have talked about some of the important tasks the case manager is assigned to. And now I would like to share some career advice for those who consider pursuing their career in international arbitration. Throughout the time working as a case manager, I had abundant opportunities to observe from the beginning to the end of resolving legal disputes through international arbitration. And I have managed around 120 international arbitration cases over the past 5 years. And those cases dealt with various legal disputes, including, but not limited to, such disputes arising from various types of contracts: construction, finance, joint venture, sales of goods, distributorship agreements, and so forth. And I think having a chance to engage in various types of cases arising from different industries can be very useful in searching your area of interest and strengthening your expertise in the relevant area. Also, it was a priceless chance for me to read through and compare numerous submissions made by counsel from major law firms, as well as to review arbiter awards drafted by prominent arbitrators of different legal backgrounds. And considering the confidential nature of arbitration, I believe it would be very helpful to have access to the submissions of leading arbitration practitioners and decision-making process of renowned arbitrators in building up your expertise in arbitration. Opportunities to communicate and work with prominent arbitrators over real arbitration cases is another merit of working as a case manager. Luckily, I've had chances to work with such high-profile arbitrators from both common law and civil law jurisdictions. Also, arbitral institutions can play essential part in the regional arbitration community or even on a global level. So working as a case manager at arbitral institution, you can also expose yourself to various networking and speaking opportunities, or to take part in arbitration related projects, which will help widen your career by giving you a chance to present yourself to law firms or companies around the world. Therefore, if you're interested in pursuing your career in international arbitration, I believe beginning your career as a case manager at an arbitral institution can be a reasonable choice, or at least adding it to your CV in any stage of your career is worth considering. Internships are also open at arbitral institutions, including KCAB International. So doing an internship can also be a good start. I remember Hye-won also did an internship at KCAB International. I hope she had a good experience. And if you're interested in doing internship at KCAB International, please visit our website at kcabinternational.or.kr. Like the Ministry of Justice, the ISDS division, we do not regularly upload job postings, but I believe 1 or 2 job openings will be uploaded in the near future. I hope so. So please check our website regularly if you're interested. Well, that pretty much sums up my presentation today. And I think in every event, the last presentations are usually the least popular ones because of the timing. So I thank you very much for now leaving the event and listening to my presentations until the end. Thank you.
Thank you, Mr. Ahn, for your very helpful perspective. If I may pose a question to you as well. When you hire an intern or when you hire a new attorney, what do you usually look for? What are some key traits that you think will make this a good candidate? And what are some things that you want to avoid seeing?
I think from my experience, the basic requirements are always important, which means if you're a law school student, it is important to have a good grades and active participation in any arbitration related activities, or even as Ms. Mentioned, moot competition like VIAC moot or FTI moot. And it is also, I believe, important to make your educational background or your pursuit of your career a story that makes your life aiming for some career in international arbitration. And I think that includes your participation in VIAC moot competition or any writing competitions, or even you can just write an article at journal or any blog, arbitration related blog like Couloir Law Arbitration or Couloir Arbitration blog or any other kind of blog. Yeah, I think, you know, to sum up, anyways, make a good story heading toward the arbitration or international arbitration. I think that is one of the most important things. Thank you.
Thank you, Mr. Ahn. And I think it's time to relay some questions from the audience. And just as a reminder for the audience, you can ask your questions through the Q&A button below. And this question is for all the panels from one of the audience. What do you think about starting an international arbitration career in academia? So does any one of the panelists want to start?
Let me just take a stab at it. I do not think there's one particular set mold, as I said, to start of a successful arbitration career. At the end of the day, I think it depends on the personal, that individual's drive and fundamental, I guess, professional characteristics that will, you know, ultimately lead to the right result. Having said that, however, international arbitration obviously is one of the most practical and practice-driven areas of the law, meaning that there are a lot of things that will occur in the front line, things that will just surface by engaging in an action that takes place while disputing your case and representing your client in a real life setting on a rolling basis. And so there may be a little bit of gap between what you can ascertain from teaching or researching in an academic arena, as opposed to dealing with submissions, arguing your case before the diverse members of the tribunal. And so my long story short, it could be one of the options, but just on a personal level, I think it may be more practical and relevant for the young practitioners to gain the real life experience of representing your client in an international arbitration in order to have a long-term career track set and be able to contribute in a practical way to your client and to your team. I'd welcome other comments as well.
Maybe I can take over Ms. Kim's comments. Yes, I do fully agree that arbitration is very practical and practice-driven area of work compared to other practices. However, at the same time, it's one of the most fast-evolving practice in the world. So it is very important that you interact with the the newest developments in the field, what the rules are changing and what the trends are. So I think interaction between the practice and academia or studying or following the researching or following the trends, the most recent developments and the trends in the field of international arbitration is really important throughout your practice in this area. So you can't stop learning. If you decide to pursue your career, you always have to learn something. That's why I said that participating in events or lectures is really important, because rules and the laws are changing every day. So it's really important to interact with your practice and also your learnings in everyday practice. That would be my comment.
So personally, I think we can take two different approaches depending on what kind of international arbitration you're interested in. For example, if you're interested in investment arbitration, I think it can be a good option to begin your career in academia because the basic rules and law, I mean the substantive laws of that governs international investment arbitration is based on international investment law or the treaties that governments adopted, or even the case laws that have been already publicly disclosed by the ICSID or any related institution. So I think in the academia, I think you can learn the substantive laws of international investment law or investment arbitration. And I think that can be very helpful to build up your expertise. But on the other hand, regarding the commercial arbitration, because of the confidentiality, the confidential nature of arbitration, not all the arbitral awards, commercial arbitral awards are publicly open. And it would be better, as Ms. Kim mentioned, to experience the real arbitration cases in the private sector or in public sector to build up your expertise in the relevant area. So I think that's my answer. And even in the case of the investment arbitration, it is still very important to make yourself known during your academia years, for example, by writing good articles in English, preferably. So I think that's my answer to the questions from the floor.
Thank you all. I hope that answered the audience's question. And we also received a question from, I think, an undergraduate. What kind of university major is best suited for international arbitration? Since we have a few questions left, let's try to answer briefly if possible. Do you want to start, Ms. Myung-Ahn?
That's a really interesting question, and one that is being posed by a lot of first-year associate or incoming junior associates as well. Obviously, I cannot represent, I guess everyone's view in the field. But my personal honest answer, however, is that there's no actually one set, major or area of the academia that will be preferred. I know in realistic terms that some of the major law firms in Korea and abroad tend to prefer economics major for their M&A disputes team or transactional teams in general. In terms of international arbitration, as you know, arbitrations are not, and Ms. and I sometimes kind of talked about this, they're like, arbitration is not about arbitration rules. It's about substantive laws. They're quite diverse and dynamic, and they cover a wide array of practice groups and specialties. And so being able to delve into the disputes substantively and being able to spot the issues and argue your side of the story will be key. And that's not driven by a particular major in your university years. It could be economics, it could be your linguistics, it could be something, who knows, you might be able to deal with some arts or entertainment areas or sports areas in your international disputes, and they're not necessarily driven by one particular area of the law or a major. So answer is not predetermined.
Ms. Young-Shin, do you have any further comments?
I totally agree with Ms. Kim's comment, and I think I also had the experience, like I also have like junior students asking questions like what would be better for them to practice international arbitration. I share the thoughts of Ms. Kim, because you can't measure everything, because you cannot expect what the disputes would come from, right? So disputes arise from various aspects of various industries, and you cannot be specialists in every industry, right? So what is important as an arbitration practitioner is like case analysis and delivering good advocacy. And so I don't think that you would have to be stuck to one or a particular major when planning your career to pursue an international arbitration. That would be my answer. Thank you.
I totally agree with the two distinguished speakers' answers, and I think mostly it depends on your area of interest. So as Ms. Kim mentioned, almost all fields of industry is related to arbitration. Any disputes can be brought before arbitration from any industries. So if you think that you would want to pursue your career in certain field of industry, then I think you might want to consider having your major in that industry. I mean, major related to that certain industry, but still it is a very early stage. So there might not be any kind of definite answer to that question.
Thank you all, and I hope that answered the audience's good question. And we also have a question related to the first session, actually, which asks, would the Korean international arbitration market be affected in any way by the Ukrainian conflict? Would everyone want to give a go? It's not an easy question.
I just think that Ms. Ahn might be best placed to answer, but if I may just, sir, I guess my answer would be quite limited to the extent that I deal with commercial arbitrations in most of the time. Obviously, the force majeure and the delay in commodities and transport, as well as construction areas, have kind of surfaced in lieu of what had transpired in Ukraine. So in terms of the international arbitration settings, that's going to be something that will be percolating for some time and may materialize into a question of fact or law in the context of arbitration, whether it be via the renowned arbitration institutions in the future. But I would be inclined to say that it's to be seen, and because of the gravity of the issue, it will obviously have some impact. But in comparison to other international developments and I guess incidents that we see in other areas of the globe, it doesn't really stand out at this point in time in terms of the quantum or the nature of the issues that we deal with and handle immediately. But it's a relevant factor, obviously, something that we see becoming an issue in the mid to long term in terms of dispute resolution.
Okay, I believe that Ms. Kim mentioned that I would be in the best position to answer this question because she was thinking of a potential investor-state dispute. Yes, that might affect potential disputes coming towards the government, but we will have to see, because as Ms. Kim mentioned, whenever something happens, the dispute arises after a few years later on. So we will have to see, and we're closely monitoring the impact of how it would rise into a grounds for potential disputes, for instance, a sanction related issue or any force majeure events that would arise into a potential dispute. So we're closely monitoring on that issue. And I totally agree that it is a huge event and it would have certain impacts, but the timing would happen in some time later. I recall that my practice in the private, I did numbers of steel industry disputes because like a few years back then, there was a huge depression in the steel market. So then after 2 or 3 years, then they started like filing arbitration elsewhere regarding the steel prices. So like I had to look up the international chart on steel price and had to learn what the price chart is going to mean. So we'll have to see, but I think that this war will bring some meaningful events or changes into the international arbitration community.
So as a counsel at arbitral institution, we do receive cases from, cases where one of the parties is from Russia or any other part of Europe. So I think generally, if there is any kind of disputes, then legal disputes will follow, and arbitration will also be one of the best options for resolving cross-border disputes. So I think it remains to be seen, but I guess that the disputes will come up in a couple of years at least. So that's my prospect. Yeah.
Apologies. I am so sorry to Mr. Lee, moderator. I might have to be excusing myself a little bit due to a inadvertent, engagement that had to, I guess, be engaged here. But I wanted to just stop by and thank you so much for all of your time. And if there are any questions from the students, I'll be more than honored to answer them to the extent I can. And obviously, thank you for all the panelists for their helpful comments. I really appreciate it, and I was helped by it as well. Thank you very much.
Thank you. Thank you. And actually, I think we just finished all of our time. And unfortunately, we had some unanswered questions, but we hope this session was still very helpful. And thank you, panelists, and thank you, the host, for organizing this event. And I hope everyone had a good time in today's session. Thank you, everyone.
Thank you, Mr. Lee and Ms. Kim, Ms. Ahn, for the lively talk. We couldn't have seen this collaboration from anywhere else. And so, ladies and gentlemen, this is the end of today's webinar. I hope you found today's presentations not only informative, but also insightful. We would like to thank Professor Joon-Gi Kim, who supported us every step of the way. And most importantly, we sincerely thank every one of you for your time with us today. So please join us again next year for YAD 2023. Thank you.